right. No, what are you listening to?
No, I'm listening nothing. I just forgot that I have it.
I thought you were listening to some Megadeth.
No, Megadeth, yes.
Metallica, she's
Metallica, yeah.
I'm what's going on.
Awesome.
Metallica and Iron Maiden. I figured that much. Probably from time to time Sepultura. Not so.
All right, so just concluding the thoughts on trademarks, we were starting to talk about generic marks, right? And how Google might have become generic. So what makes you think that?
Because of the use.
The idea that for everything you say, just Google it.
Yeah.
No
Because
matter
of the use.
the engine
Yeah.
you use.
So they are not meaning the real.
It's not that you intend the site.
Yeah. So do you use other search engines or do you use Google personally?
No.
You use
Chrome
Google.
I use
or
Google.
Internet Explorer.
Just reflex, so
Yeah.
you can change it.
Who uses a search engine other than Google? What do you use?
No, I was with the idea that Google is not generic to me,
And why is that?
because whenever I use some other search engine, I always find myself back to Google, because
Huh?
I think it's, at least that's my personal opinion, how I feel about it.
Sure.
I can find more things in Google or easily
Yeah.
than maybe Yahoo or some other.
I agree with you. But when you're in conversation where you're saying you're going to search for something, you say Google it?
Yeah, this is
Yeah, probably.
Yeah.
even if you are in another search.
Even if you're in another search engine, you say Google it.
Personally, I don't have.
You don't like it as a search engine?
The expression.
Because it seems like we don't have words.
Well, what phrase would you use?
Search it.
Search about it.
Search about it. Okay. Really? I mean, that's a good thing. In conversation, though, that's what you would say?
Navigate.
If you were in a conversation with me, you would say search it?
You'll say Google.
I would say Google it.
I almost say Google.
You would say Google it.
Yeah, Google it.
Yeah. All right. Well, it's interesting. Does anybody know any? So that's a mark that Google is a mark that some might argue is already generic. Of course, Google will take issue with that, and they will do anything to prevent a court from deciding that their name has become generic. And it's, in America today, it's kind of difficult to imagine a court would say, oh yeah, it's generic, right? Because Google would spend so much money on lawyers and lobbyists and whatever. But could happen. Does anyone know other marks, particularly in America, that have become generic over time?
I would say for kind of sneakers.
Snickers,
Converse.
Converse for shoes.
Yeah, for the
Shoes,
shoes.
sports shoes.
The sports shoes.
Or
At least in Albania, it is generic.
Converse. You would
Yeah.
say Converse when you mean gym shoes.
Whatever kind of shoe that looks that way. I mean, and it's not Converse. We say
Converse.
Converse. Yeah.
Huh.
So also.
But that's good because the brand is well known, so you're referencing.
But that's the thing about generic marks. It's when brands become too strong that they become generic. You just describe any category of sneakers. Yeah.
That look like.
Yes, but.
Converse has
We say, I said before,
big gowns, small gowns, maybe just like the look of the shoe, maybe.
We don't make any distinction between big, small categories. Converse. I'm buying a pair of Converse and that's all.
like you say for Safari. Safari case, you understand that Safari is something.
Safari, what is
once
it?
on the time, many years ago, Safari was a trademark, and then became generic because
Of
it was
going
not
on
anymore.
safari in Africa? That?
Exactly, because the meaning the Safari was.
It was
for
a
this,
trademark? That
yeah.
I didn't know.
Yeah, and in
We have a case.
Only
Some
for clothes, not for
Only
some
shoes.
for
articles
clothes.
it has become generic.
Okay, very good.
It's a case about Abercrombie and Fitch.
Like you
We
say,
studied it before.
Safari jacket.
Okay.
Because as you said,
You use the
see-
term safari jacket,
Yeah.
intending the jacket, not the.
Okay, very good, very good. Here's a list of some other trademarks in America. Some of them you might know. Aspirin, right? Used to be a brand name, is now generic for that kind of pain reliever. Butterscotch. You know what butterscotch is? It's a candy flavor, like a yellow candy. Escalator was a brand name. Now it describes any moving staircase. Heroin, one of my favorites. Heroin was a brand name. Now it just describes that drug. Thermos. Do you use that word? Thermos for the insulated liquid carrier. Yo-yo and zipper. Formerly trademarks, all genericized, and all of those mark owners would have been unhappy when that happened.
And Murphy bed.
Murphy bed, okay. I didn't know that one, but all right. I mean, it describes any bed that comes out
Yeah.
of the yeah. But it makes sense because, you know, in that trademark, there's nothing descriptive about that, right? But it somehow became generic. Okay. Other ones I think, so we talked about a couple that might become generic. Other ones that I think are at risk are Kleenex for facial tissues, Band-Aid for adhesive bandages, and Xerox.
Xerox too.
Well, I don't know, in America you would just say Xerox this when you want a photocopy of something. Xerox it. Even though Xerox hardly makes photocopiers anymore. It's a brand, it's a company that has really failed.
Yeah.
They don't make anything anymore. All right. So concluding the thoughts on trademarks, going back, so when we finished the thoughts on patents, we compared them to copyrights, right? So now trademarks. Unlike copyright and patent, for a trademark, you don't need any novelty. For copyrights and patents, it has to be new, original. For works of authorship, have to be original. Patents have to be obvious, non-obvious, and novel, right? But for trademarks, you don't have to have any ingenuity about you. Pick a name, start using it, you have trademark rights. Okay, so that's one differentiator for trademarks. And again, as we said before, with patents and copyrights, they either exist or they don't. They're one strength. But trademarks, while there is that initial hurdle you get over, to have one or not, once you have one, it can get stronger and stronger and stronger, or weaker and weaker and weaker. Can even go away completely, for example, if it becomes generic. And for copyrights, the test for infringement is whether the would-be infringer is doing one of the 5 exclusive things, right? Duplicate, distribute copies, etc. For patents, it is whether the would-be infringer is practicing the invention, right? Not about copying. What's the test for infringement for trademarks?
Similarity in appearance or in
That's part of it, but not the only thing. So, for example, I can have a trademark in the United States where if I have a car garage where I fix cars, and I happen to call it Panera, like one of the marks in the film, that's not necessarily infringing on the Panera Coffee Company trademark, right? Even though they're identical. Not only similar, they're identical. So there's more than similarity or even identicality required for trademark infringement.
Strength of the mark.
Well, the strength of the mark would probably have a bearing on it, but I could still, even McDonald's, right? There are still other businesses in the United States that call themselves McDonald's. Like if my last name is McDonald, then again, I have the auto repair shop, I could call it McDonald's, even though it's hard to think of a stronger mark.
The test for the trademark is the time of being in market.
The what?
The time of being in market.
The time, well, that goes to the strength of it. But the test of infringement is the likelihood of confusion of the public.
The area of the market, where do you?
That has to do with it also, the area of the mark. So the test for infringement is likelihood of confusion among the consuming public, right? And all these things have to do with it. If I'm operating, a school called Chicago Kent in Illinois, or even in the United States, I would think that any other school in Illinois or the United States is likely to confuse the consuming public that it's from the same folks. But if I were to do it in Athens, call it Chicago Kent, and maybe I don't use the logo, you might argue that there's no likelihood of confusion. The people who might go to school there don't think it's coming from the same source of goods or services. So whether it's likely to confuse the public has to do with all these things. You know, outside of my geographic area, or my mark's not very strong, or I'm selling a different kind of products or services.
There is a test of 8 Slaycraft test.
Yeah, but they all, those points go to the likelihood of confusion, right? And then it's just figuring out how do you determine whether there's likelihood of confusion. The easiest way to determine whether there's likelihood of confusion is show actual confusion, right? When you're trying a case on trademark infringement, that's what you always do. Bring in, oh, we surveyed 100 consumers on this mark, and 98 of them said they were actually confused. Not, they might be, they're likely to be, they are confused. That's great evidence of likelihood of confusion. So with trademarks, you can have the exact same trademark and not be infringing. That's unlike patents. You can copy someone else's mark and not be infringing. That's unlike copyrights. If I see your mark and I like it and I want to use it for my goods and services, and I'm not likely to confuse the consuming public, fine, no problem. This tells us that the purpose of trademark law, once again, is not to protect the owner of the mark. That is like copyright and patent. The purpose of copyright, the purpose of patent, to promote the progress of science and the useful arts. The purpose of trademark, to protect the public from inferior goods and services, not to protect the mark owner. In order to accomplish that goal of protecting the public, we protect the mark owner because they'll enforce the mark. All right, any thoughts, questions, comments about patents, copyrights, or trademarks? One last IP, there are other types of IP, right? Like mask works, which have to do with computer chips, the right of publicity in the United States, which is really most important in the entertainment industry. But one more for us to talk about is trade secrets. Okay? It's another kind of intellectual property right. What do I need to do in order to have a trade secret? So in order to have a copyright, I need to fix an intangible medium. In order to have a patent, I need to get that thing issued from the government. In order to have a trademark, I need to use my mark in commerce. What do I need to do in order to have a trademark, trade secret? I don't even necessarily have to have a procedure, but how you ended that.
An agreement.
Protection of it. Protection of it, yes. I have to keep it secret. In order to have a trade secret, I need to keep it secret. And I will do that through a number of ways. If I'm ever going to disclose it to someone, I need a contract that says I'm disclosing it to you, and you won't disclose it to anyone else or use it. And I might have a process around it. If it's a technology, I have a process on data protection. But all these things, again, go to, at the core of trade secrets, are keeping them secret. So, like copyrights and trademarks, I don't need any government action in order to own a trade secret. If I just keep it secret, I have one. Unlike any other intellectual property, there is no registration available. So not only do I not need a registration in order to have a trade secret, I cannot get one. There's no process for registering a trade secret. It just is, by virtue of the fact that I'm keeping it secret. How long? So copyrights last for the life of the author plus 70 years. Patents for 20 years. Oh, we didn't talk about the lifespan of a trademark. How long does a trademark last?
10 years.
10 years?
Renewal.
Huh?
With renewal.
With renewal. How many renewals can you get? Anybody know? What's the...
There's a procedure with USPTO office. You have to prove the strength of the mark.
Yeah, there's a
It
procedure.
is.
Or in your territory, is there also a procedure? How many times can you go to the USPTO and renew?
How many you want?
Yeah,
You can do it like
forever,
forever.
right? And even if you don't register, a trademark potentially lasts forever. Remember, it doesn't stem from the Constitution. Nothing says in the Constitution or elsewhere trademarks have to have a limited lifespan, right? They can last forever. As long as you're using the mark in commerce and it denotes the source of the goods or services to the consuming public, you have a trademark. And it can last forever. For many reasons, that's why some would say trademarks are the most valuable intellectual property. And if you talk to Nike, Coca-Cola, that's why they would agree, because they don't have to go to Congress and lobby to extend the term every 10 years or whatever. As long as they keep using it, they have the trademark rights and keep enforcing it. What about trade secrets? How long do they last? What's their lifespan? Forever, right? Until it's not secret anymore.
It's disclosed.
The interesting thing about a trade secret is you can lose, the owner of a trade secret can lose the trade secret protection through no fault of their own, right? If I hire an employee and I have them sign a non-disclosure agreement and they have access to my secret formula and they breach that agreement by disclosing it to the world, I don't have a trade secret. Too bad. They breached the contract, but now the world knows my secret. And you can't, as they say, you can't put that genie back in the bottle. It's out of the bottle. I lose my trade secret protection. I might have a claim as against that employee for breach of contract, or against another corporation who hacked into my system and stole it. But once the public knows about it, the public knows about it. Probably one of the more famous cases in the United States on this issue is Famous Amos. Anybody know that case? Famous Amos was a guy who made the most delicious chocolate chip cookies you could imagine. Started a business with a secret recipe, was selling cookies, and he, like the Coca-Cola people, tried to protect his formula with non-disclosure agreements with employees. Somebody published the recipe on the internet. Boom, no more trade secret.
Like Krabby Patty.
Huh?
Like Krabby Patty.
I don't know.
SpongeBob and
SpongeBob?
yeah, they have the secret of the recipe.
That I'm not familiar with, but so the Coca-Cola people have done a much better job of protecting their trade secret, right? Who here has negotiated a non-disclosure agreement? Probably most of you, right? At some point you've negotiated some kind of non-disclosure agreement. Only one of you? It's hot in here, but it's not
It's
that.
more like actually part of it.
Yeah.
As a part of another agreement.
It's more
Yeah.
included in an agreement.
Okay.
than
I
just
find it as a separate agreement everywhere.
I get them all the time, either as separate agreements or as part of something else. And what do you do as a lawyer when you have a non-disclosure agreement or a non-disclosure provision in a larger agreement that says trade secret or protection for the confidential information expires after 3 years? What do you do? What's your advice to your client?
Don't sign it.
Well, maybe don't sign it, but maybe they don't care. Maybe they don't care, right?
Until I don't figure out something else.
You
We
mean
have-
the licensor or the licensee?
No, for the information that you have.
The one who's giving the permission?
Well, let's say it's a mutual.
Yeah,
Most
Both
of,
of them.
Because
many of the confidentiality provisions I see are mutual, right? I'll protect your information, you protect mine.
make the best out of it.
Okay. Well, meaning what?
Ask for as much as possible.
As much information as possible?
And in return for money.
Oh, for money. Ask for money. Okay. Well, let's say you have a non-disclosure agreement or a provision in a larger agreement that lands on your desk and it's got a confidentiality provision in it, which you're probably, if that lands on my desk, I see a confidentiality provision, I go, okay, we're going to have confidentiality. I don't really even ask my client, right? Okay, there's confidentiality in there, fine. But if I see an expiration date, I have a standard plan of action. What would you do? You just get an agreement about we're licensing software to you, and you're going to load it on hardware. You're going to sell hardware, and I own
I would say.
Adobe, and I want you to put Acrobat on all these computers that you send out. Manufacture copies of Adobe, put it on there, and as a part of this, you're going to have my confidential information because you're going to have access to the source code and you're going to know how many copies I sell and what my profit margin is on it. All that's confidential information. So, in the context of that, a non-disclosure agreement that says it expires after 3 years.
It's not a non-disclosure agreement because 3 years pass so fast and all this confidential information stays for 3 years. So, in my position, I would suggest to my client to have for indefinite.
Indefinite. Until.
Not a term, not for a short term.
Okay.
And
Anybody
usually all the NDA that I have seen, they do not have a term.
They don't. Well, you see them with a term and you see them without a term.
I would go and somehow register the copywriter.
No, it's still.
But what if it's about
Make us
financial
sure.
information?
Yeah.
You know, there's really no copyright you can
Yeah.
get.
It could be something about that.
Invalidate it after some time, after the agreement is expired.
Invalidate what? The
The financial information or credit.
okay.
Excuse me, but what to tell to the client from what?
Yeah.
I don't know. You tell me. I'm just saying. A contract lands on your desk. It has a confidentiality provision in it. It says the protection expires after 3 years.
Where is it that?
I'm not saying it's bad. I'm not saying it's good. What do? Would you just say okay, 3
No,
years, fine?
I wouldn't agree. I wouldn't agree at all.
No, you should just remove the expiration date.
Okay.
I wouldn't agree with this
Depends on
term.
what is
No.
the
There is confidential information. There is a reason why I keep it
Yes.
confidential. And if this information for 3 years, I would evaluate things. This information should be confidential for 3 years, or it will go on after 3 years. So to me, this term is not.
That's
So
practical.
I would say to my
That-
client, no, to not
Don't
accept.
sign.
That's practical and easy, but easy answer. There's
No,
something more to it.
indefinite,
I don't know.
indefinite.
What would you say?
You can add a clause in the contract where you can forbid that person, that licensee, to use your product in future after the expiration date.
Okay.
It's still a
If they keep
term.
it confidential.
Still, yeah.
So if he signed for that clause, that he's not going to use your product or that knowledge or that secret that he has found out. In my country, we can use that clause.
To go on for some time after the contract ends.
Yeah,
Yeah, sure. I don't think there's a magic answer to this. My point is, as the lawyer, when it winds up on our desk, 3 years might be fine, 1 year might be fine, forever might be fine, but usually we don't know the answer to that question. We have to ask the client.
Depends on the
It depends from the information, confidential information.
I would tell the client, hey, anything you tell them, they can do whatever they want with it after 3 years. Oh, is that okay? And if they say it's okay, fine. If they say no, not fine. If it was, the example I always give to my clients when I see one of these expiring NDAs is the Coca-Cola company. I always tell them, I don't know if you're going to have a Coca-Cola problem. Here's what it says. Do we need to change it? So Coca-Cola is a company that was formed, I think, in 1896. It's got the secret formula to the soda. And here we are, 96, 06, 16, 123 years later. If the Coca-Cola company had signed an NDA that expired after 3 years in 1896, well, we'd be, 124 years of lost protection, 124 years and counting, right? So it's not like there's any right or wrong answer on this. It's just that as lawyers, we really know what the business issue is or what's an issue.
some technology that time with the 3 years time period will pass on.
What about the 3 year time?
Maybe some kind of technology that after 3 years will be
Obsolete.
No one will care.
Yeah. So 3 years might be fine. Usually clients tell me, when I explain to clients that, this whole Coca-Cola thing, usually they're like, oh, I'm not going to really tell them anything secret anyway, right? Because in today's world, non-disclosure agreements are like candy. And just, here, sign non-disclosure, sign non-disclosure. And I ask my client, well, what are we going to be telling them? Nothing. Well, why are we signing this? Because they won't talk to me until I sign it. What are they going to tell us? Nothing. Well, why are we signing? Just because some lawyer has said, before you have any conversation, get one of these signed. It's kind of silly. But in a way, it keeps us in business. I have one client, God bless the clients because, when they send me things, they pay me by the hour. and they probably send me 3 non-disclosure agreements a week. Each one takes a half an hour. My rate's $500 an hour, so it's $750 a week for, you know, doing nothing. Yeah. I tell them about the Coca-Cola thing. Good job. And then they go and do what they're going to do. So God bless them. Don't show this video to my clients. No, but it's actually, but it is a useful service to them because you could tell them, you know, if in the odd instance that they are going to be disclosing something that's important and that has potential long life, then they understand, oh, okay, expire in 3 years. And it's bad for clients to just sign, you know, oh, it's just an NDA, I'll just sign it. Because sometimes lawyers put, I call it a zinger. I'll put my zingers in a non-disclosure agreement, right? Like, oh, it says non-disclosure agreement at the top, and the first paragraph is about non-disclosure, but then, you know, 3 paragraphs down it says, you licensed to me this technology. I can use the residual information, or you won't poach my employees, you know, all these things that can wind up in a non-disclosure agreement that have no business being in a non-disclosure agreement. But sinister people out there who know that these things just get signed, they'll put in there some kind of zinger, you know, some kind of gotcha. So it's wise for clients to send the non-disclosure agreement to the lawyers for sure. Many clients don't. Okay, so that's trade secrets, right? So as differentiated from the other intellectual property types, you don't need any government action. In fact, you can't get government action. They potentially last forever, like trademarks. And what you have to do to have one is keep your information secret. And what you have to do to show infringement of one or misappropriation of one is like a theft case. Right? It's not about copying. It's not about practicing the information. It's really more like, did you steal my bicycle or not? Did you take my trade secret when you didn't have the right to do it? That's the test for infringement on the trade secret front. All right, now let's talk about contracts. We already said the catchphrase in this class. What do you need to have a contract? Offer, acceptance, and consideration. Right? Probably in your legal systems, it's the same thing. Offer and acceptance are pretty easy concepts. Consideration is the one that in the U.S. can trip people up. So let's talk about it for just a little bit.
Which we don't have in our system.
You don't have it in your system.
No,
So
we don't.
if I agree,
So we have it, but
Not like that.
not like that.
tell me, what do you have?
For example, we give
A gift.
a gift in USA, we understand it's not a contract.
Not enforceable, correct.
We have it as a contract.
Really? So if I promise you I'll give you my car, and you say yes, great, and I don't give it to you, it's enforceable?
Yes.
No, that's a kind of promise. But if I say I'm giving you,
Yeah.
and I need to have your signature, your approval, because you might refuse it,
Should be
Okay.
written.
and then, which I don't understand how it works in USA on the other hand, because here are tax involved, taxes or duties to that,
Well,
to that property.
let's take it out of the realm of valuable things, right? So let's go back to bicycle. If I sell you a bicycle, there's no tax, right? For $50 or €50.
Yeah.
So let's keep it at that. Keep the tax issue
More
on.
like in immovable properties.
So if I say I'm going to give you my bicycle, you say great, and then I don't give it to you, is that enforceable? It's a gift.
It can be because
It's not enforceable.
Well, let's say I wrote it down.
Yeah.
if you wrote it down, it's in our law. This agreement should be written.
Okay, well, let's say it is in writing.
If it is written on,
It's enforceable.
then I can ask you. I can claim it.
Okay, all
And
right.
ask
And even if I give you the gift,
and then there is an one provision that it says that the
Opinião final do
agreements that are not, that should be in written, and they are not, like, they don't have that kind of form. If they are fully realized, for example, that then they can be taken as a, they can be enforceable. They can be,
I already gave it to you.
yeah,
You can't ask for it back.
yeah.
You can. If
And
you're
I
not
accept it.
taking care of the gift, I
Yeah.
can take it back.
Yeah.
Or if, for example, there's a condition, there's few conditions. For example, if I try to kill it,
Yeah.
then you can claim it that I didn't develop the.
It's connected
I
with the
was
behavior.
unthankful.
Not thankful.
Okay.
Unthankful.
Not mindful enough.
Or if I mistaken to you something, not
Mistreated you. Or
mistreated you, you can say on a court that he was unthankful
Yeah.
to me, so.
Or for example, if you give someone a car, and if that person who receives the car tries to scratch the car or show any intention to destroy or ruin that car,
You can take it back.
Yeah.
Yeah.
Wow.
Or tries to sell it.
Or tries to sell it.
And you didn't, and you said in the agreement that he cannot sell.
Okay. So in the United States we don't have any of this. In the United States it's offer, acceptance, and consideration
For any kind
Mutual
of property.
assent.
for any kind of contract.
And not movable properties.
Yes.
You can do it, for example, for one house.
For a house, offer, acceptance, and consideration.
Consideration.
Only enforceable contract.
The rights of the ownership, how they transfer, or how they write in this case. If I'm going to will this,
If it has to be in writing in certain cases. I'm not sure what your question is.
Does
so
it say
if I'm going to
give you
to
the
give
house
you the house,
as a
and
gift?
the house is mine, it's
Yes.
registered in my own
Yes.
ownership,
Yes.
and you have it through this process without any forms. How you can register it in the house and the rights of the
Well, you could. So are you saying a gift,
The-
or I'm buying
As
it?
a gift. As a gift.
Well, it has to be in writing. He would have to, if you want to gift me your
So
house.
that's the reason why we made this confrontation between our systems and your systems. So some properties needs to be fixed in the
Register,
forms
sure.
because the ownership is transferable by this kind of act through the
Yeah.
sale or through the gift or through another thing.
The thing is that we for gift we have to have approval from the other party. Who's receiving
But
it.
it's
the
a condition.
acceptance.
It's another
They
condition for
don't
the
need the acceptance, the approval of the acceptance.
That's true. For a gift, you don't need. If you wanted to transfer your
You
house
have to
to
have
me,
it in writing, but
if you wanted to transfer your house to me as a gift, and I said I didn't want it, you could write out a deed that says your house to me and take it and record it. I'm the owner of that house, whether I like it or not. I can't imagine that ever happening, but I think it would be enforceable from a legal perspective. But in that situation, it's not a contract because there's no consideration. And also, you couldn't take it back. Once I have title, it's mine. What?
If it's a will, you're giving it.
In a will, okay, yeah. But even in a will, you would still have to, again, in the solemn form, also have a deed. The will says you leave your interest in that property to me, but I don't own it until the deed comes. Right? It's different with a watch. If your will says you leave the watch to me, once you die, I own that watch because there's no solemn form. But in the United States, it's not an enforceable promise unless there's consideration. The catch in the United States is consideration is anything of value. Anything. In fact, you go back to Supreme Court cases from 100 years ago or more, what the judges or the justices would say then is, even a peppercorn is enough. I guess in Greece we would say, even an olive pit is enough, right? It has some value, not much value, but some value. And that is sufficient for consideration. So even though in the United States we need offer, acceptance, and consideration, consideration is a very low bar.
So anything of value
Anything of value?
translated into money, correct?
No? Of value.
Because it might be
Means-
also spiritual value.
Anything of value.
Of value.
Anything of value.
Anything.
It has to be a thing.
Tangible.
And under U.S. law, it doesn't have to be a fair deal, right? If you say, I will sell you my house, which is worth $1 million, for $1, and I say yes, and we write it down, there's no problem with enforceability we're talking about offer, acceptance, and consideration only now. That's enforceable, because we each agreed to give something of value. It doesn't have to be a fair deal. All right. Then, I think we started to go down this road before. Once you have offer, acceptance, and consideration, there are certain instances in which that does not create a contract. So, I say I'll sell you my house. You say okay. I'll sell you my house for $100. You say okay. Offer, acceptance, there's consideration. We're each giving something of value, but there are certain instances in which there is no contract created. For example, give me one.
You are mistaken?
You're mistaken. Yeah, so I own 4 houses, right? We said, I'll sell you my house for $100. He said, yes, we don't know which house, right? Okay, mistake. Fraud, right? I tell you, I'm going to sell you my house for $1 million, and it's worth $1 million because the king used to live in it. He didn't. That's fraud. I made a material representation of fact to you that you relied on to enter into the deal, and it was a misrepresentation, fraud, no contract. Actually, that's a defense. So we'll get to defenses in a minute. We're talking now about there is no contract. Mistake, no contract. We never had a contract because we didn't agree. The other, a couple other instances in which there would be no contract is if the parties aren't competent to contract, right? If you're a minor, if you're involuntarily intoxicated,
With low IQ.
low IQ, or some other mental impairment. Yeah,
Mental disease.
yeah,
Disorder.
mentally disabled. Yeah, there you go.
Under duress, how do you call it?
That would also be a defense. I mean, I think we would have a contract in the first place. So this is kind of tough to get your arms around, I think, from the outset. But there are certain instances in which we have offer, acceptance, and consideration, but no contract was ever formed. If you're a minor, if you don't have mental capacity, then there are other instances in which we have offer, acceptance, and consideration. We do have a contract, but one or the other party can void it because they have a defense. Fraud is a defense, for example. Duress is another one, for example.
Also because it becomes too unfeasible, let's say, like
Impossibility.
impossibility.
Yes, that's another one. So I'll sell you my house for $100,000. You say yes, but before we actually consummate the transaction, the house burns to the ground. Neither one of us can enforce that contract because the purpose has become impossible. Okay? All right, let's just cover one more thing before we take a break. So we've talked about intellectual properties, what they are, how you get them, how long they last, how they get infringed. And then the way of getting access to an intellectual property is through a contract of some type, and often that contract is a license. So in a lot of licenses, who's worked on any kind of IP license? Anyone? You were saying this. Nobody does it because the system's not developed, right? Okay. All right, well, even if you haven't worked on any, what kind of provisions should be in an IP license that aren't in some other kind of contract? Let's say I'm selling you, I sell plastic cups, and you want to buy plastic cups. So we enter into a contract for you to buy 100,000 plastic cups for, $100. That contract would contain certain provisions like, I'll deliver the cups, you'll pay me, If there's a dispute, it'll be in Santa Clara, California. Those kinds of things would be in almost any contract. What about an IP license? What might go in an IP license that you won't find in other types of contracts?
I have an example, not sure if it applies. We had a client at work that sells watches, and they give license for selling, but they don't give them license to use their copyrighted images on the website.
Okay.
They close the website.
Yes. No, that's great. So this would be, sort of a protection of the intellectual property, right? If I'm selling you cups, I don't need to protect my rights really in any way. I'm selling you cups, you're giving me money. Clean deal. But in intellectual property, I'm licensing you my trademark for the watches, but I'm telling you a scope around those rights. You can't use it on your website. You can't now create another product and name it something similar.
Or you cannot give the
Put
license to someone
You
else.
can't sub-license it, right? If I sell you cups, you can do whatever you want with it. If I license you my trademark, you can't then
Or
sub-license
you
it to
cannot
someone
go
else.
with this license on other territory.
So I'll put territory restrictions on it, right? Only in Greece.
So
Yeah.
you put limitations.
Hmm?
So you put just limitations.
Yeah. Well, all we're doing is listing things that aren't in a license that
Limitation and
aren't.
instruction how to use.
Or even the distribution.
What's that?
Limitations
You should
and
have the
instruction how to use.
Instructions how to use. Yeah, maybe not.
quality.
Not necessarily the
Huh?
rights.
You can say that they should produce that kind of quality, that you're
Same.
going to control the quality from time to time.
Yeah.
The distribution could be only to licensing, not to other parties.
Right. You can't sub-license it to someone else.
Okay, sometimes.
Correct.
It's related.
Correct.
Sometimes not mentioned.
All right, yes. So with a license, we have a lot of interesting provisions that we won't find in other types of contracts. And what we'll do, probably not until tomorrow, but what we'll do tomorrow morning is we'll actually start to look at some licenses and look at those provisions and see how they're important, how they're not, how they can be problematic or not. Okay, we haven't been back, quite an hour yet, but it's hot in here, so let's take a break.
Too hot.
Let's take another 10 minutes.